which further promoted this approach was NLRB versus Laughlin Steel. NLRB stands for National Labor Relations Board, and Laughlin Steel was a steel company in Pennsylvania. And let me explain what happens in this case. United States Congress passes the National Labor Relations Act, which is a comprehensive system for regulating labor management relationships. Now, Laughlin Steel is a manufacturer of steel in Pittsburgh and Aliquippa, Pennsylvania. And what happens is they decide they don't want to negotiate with their employees. That was seen by the National Labor Relations Board as a violation of the National Labor Relations Act. So they sue Laughlin Steel in court saying they're violating national law. Laughlin Steel says this is intrastate commerce. We're talking about regulating workplace standards and behavior within the state of Pennsylvania. So it's appealed all the way to the United States Supreme Court. And the court ends up upholding the right of the national government to do this. And they said that they will uphold commerce-based laws if there is any rational basis upon which Congress could have found some relationship between that regulation and interstate commerce. So why did they uphold it in this case? What was the relationship? Well, the Supreme Court argues, in this case, 75% of the product that is produced by Laughlin Steel is sent out of state. So therefore, a labor stoppage in Pennsylvania would have a substantial effect on interstate commerce. And then not only that, but Laughlin Steel also owns mines in Michigan, owns other steel companies in Minnesota and West Virginia, has warehouses in Chicago and Cincinnati and Memphis and Detroit. So a work stoppage in Pennsylvania would affect all of these other states. So what the court did in this case, it came up with the substantial effect on interstate commerce test. And that's pretty much still the same standard we use to this day to determine whether or not the national government can regulate a state activity in the name of interstate commerce. And as you can see from these two cases, these are broad delegations. Okay. Well, are there any limits? Are there any limits? And the courts have said yes. So that's where we get to this example of regulating guns near schools. As you all probably know, that's a real case. And it's called Lopez versus the United States. And in this case, Alfonso Lopez, and again, Lopez versus the United States. And in this case, Alfonso Lopez is a 12th grade student at Edison High School in San Antonio, Texas. And he arrives at the school carrying a .38 caliber handgun, loaded with 5 bullets. He's arrested and he was charged for violating the Gun-Free School Zone Act of 1990, in which Congress made it a federal offense for any individual knowingly to possess a firearm at the place that that individual knows or has reason to believe is a school. He was convicted under the federal law and sentenced to 6 months in prison and 2 years of supervised release. And Alfonso's lawyers appealed the case, and they moved to dismiss his federal indictment on the grounds that this Gun-Free School Zone Act was unconstitutional because it was beyond the power of the national government, beyond the power of Congress to legislate control over public schools, which are under the control of the states, not the national government. So it goes to the United States Supreme Court. The United States government argues that they had the power to pass this legislation pursuant to its ability to regulate interstate commerce. They argue that the possession of a firearm in a school can result in more violent crime, and that violent crime can be expected to affect the functioning of the national economy in 2 ways. First, they said the costs of violent crime are substantial, and through insurance, the costs are spread throughout the entire national population. Secondly, they said that incidents of violent crime in a state can reduce the willingness of individuals to travel to areas within the country that are perceived as unsafe, therefore affecting interstate commerce. Well, the lawyers for Lopez argued that's ridiculous, that's not interstate commerce at all. So it goes to the United States Supreme Court, and the United States Supreme Court rejects these arguments made by the national government, claiming that to regulate in the name of the Commerce Clause, an activity must, quote, substantially affect interstate commerce. They continue, the court has never declared that Congress may use a relatively trivial impact on commerce as an excuse for a broad general resolution of state and private activities. They continue, that such tenuous reasoning would remove virtually all limits to federal power. So if we were to accept the government's argument here, we would be hard-pressed to posit any activity by an individual that Congress would not have the power to regulate. So as you can see, the United States Supreme Court does put some checks on national government power pursuant to its idea of interstate commerce. Okay, but we said that when we talk about the Commerce Clause, it really had 2 effects. First of all, it tells us what power the national government have, but we said that it also suggests the Dormant Commerce Clause. The Dormant Commerce Clause, and we want to talk about that idea now. And the idea of the Dormant Commerce Clause is if that a state law affects interstate commerce, it can be held invalid. So again, what we're saying is the Commerce Clause has 2 kinds of impacts. First of all, I could say what the national government can do, but alternatively, it can also say what state governments can't do. can't do. So if a state law, again, affects interstate commerce, it can be held invalid. So what does that mean? It blocks a state from regulating in a way that would materially burden or discriminate against interstate commerce. So that kind of gets us to these questions. So to look at these, can the national government do it? Okay, so this is pursuant to the Commerce Clause. Can it impose air pollution standards? The United States Supreme Court has said yes, because air pollution has a major impact on interstate commerce. Can it impact the national drinking age? The court here said no, that the drinking age is purely a matter of state law. Can it impact the growing of wheat in Ohio? Yes, they can pass these laws, as we saw with Wicker versus Filborn. Can it regulate guns near schools? No, that's entirely a state function, and they were giving a trivial interstate impact. Okay, well now let's go to the dormant Commerce Clause. Can the state government regulate the size of trucks? Can it regulate the dumping of toxic waste in its state? Can it regulate the execution of minors? Can it regulate the imposition of a 3 strikes law, that for any 3 felonies you can be placed in prison for life? All right, those are the kinds of things that deal with the dormant Commerce Clause. So let's look at some of the cases that deal with these kinds of issues, and let's try and get a sense of why they can or can't do something. All right, so let me give you a couple of examples. Raymond Motors versus Rice. South Carolina State Highway versus Barnwell. And Philadelphia versus New Jersey. All right, so if we look at Raymond Motors versus Rice, this case dealt with a Wisconsin regulation that barred trucks larger than 55 feet long in their states. And it was challenged by the trucking industry. So it goes to the United States Supreme Court, and the question is, can a state regulate trucks over a certain length? Now, I don't know about the rest of you, but when I drive on a highway and I see these really long trucks, these double tandems, sometimes triple tandems, it scares the hell out of me. And usually what I try and do is first I get right behind it, then I get into the left lane, then I go 110 miles an hour so I can get past it really quick before the back truck gets me. So, I'm really nervous about the length of trucks. But I guess maybe I'm just a finicky driver, I don't know. So is this something that a state should be allowed to regulate or not? Now, this case is similar, before I answer the question, to South Carolina State Highway versus Barnwell. And in this case, the state of South Carolina regulated trucks wider than 90 inches and weighing more than 20,000 pounds. They were prohibited from driving on South Carolina's highways. Okay, so you have cases that both deal with the regulation of the size or weight of trucks. Now, what happens in these cases is that the Supreme Court comes up with opposite conclusions. So can the state do this in Raymond Motors versus Rice? The Supreme Court says no. Can South Carolina do this in South Carolina versus Barnwell? They say yes. So the question is why? What's the difference? What's the difference? Well, in Raymond Motors versus Rice, the Supreme Court struck this down as a burden on interstate commerce because, first of all, there was no actual evidence that trucks over 55 feet were any less safe. Secondly, that it was a substantial burden because it was done in a discriminatory manner. The state exempted various kinds of trucks. So in other words, if you were a dairy truck, they said you were exempt from this regulation. Well, okay, that's discriminatory in regard to interstate commerce. So because of that, they said that the Wisconsin law was illegal. Now, the South Carolina law, they upheld. Why? They said, first of all, there was no discrimination, that the law was applied equally to every type of truck. Secondly, the state, in this case, they said, had a particular local concern that there were certain portions of the South Carolina highways that were very narrow, and that there were numerous studies that showed that this 100 miles of South Carolina highway, which was only 16 feet wide, had substantial accidents when trucks were wider than 90 inches. So therefore, in this case, South Carolina could impose that law. Okay. Well, what about Philadelphia versus New Jersey? In this case, the state of New Jersey prohibited the importation of most solid or liquid waste which originated outside of the state. So the question is, can't they do that? And the United States Supreme Court held they could not. They said that the dumping of waste and the accepting of waste was a commercial activity. And this was an interstate commercial activity. So that the state government could not regulate this, only the national government could. They said that the New Jersey law violates the principle of non-discrimination because it imposes on out-of-state commerce interests the full burden of conserving the state's landfill space. A state cannot afford its own residents preferred rights over consumers of other states. That defeats the entire purpose of interstate commerce. That out-of-state waste is no more harmful than New Jersey waste. Well, what these cases do, in regard to what we're referring to as the Dormant Commerce Clause, is they come up with a test that the Supreme Court imposes against the state. And here's the test to determine whether or not a state can do something. First, and it's a three-part test, does the regulation pursue a legitimate end? Secondly, Is the regulation rationally related to that end? And thirdly, is the regulatory burden imposed on interstate commerce outweighed by the state's interest in enforcing the regulation? So again, if you look at page 57 in your book, and you look at the rear fender mudguard example that they provide, they says the statute is not constitution. That truckers traveling through Georgia would have a problem. What is legal in Georgia is illegal in other states, including Florida, and vice versa. Clearly, the Georgia law would affect interstate commerce. Even though Georgia's purpose is passing the statute was to increase safety on our highways, a possible increase in safety would not justify requiring truckers to either avoid Georgia or change their mud guards before they pass through. Okay? So, applying that standard, what we see, can they regulate the size of trucks? Well, the answer is maybe. Right? Does it pass the three-pronged test? Could they outlaw the dumping of waste from other states? The answer to that was no. That's interstate commerce. What about these? Execution of minors. 3 state laws, 3 strikes laws. All right, these deal with a little different kind of issue. So, can a state execute minors? Well, the answer here is no, but it's not because of interstate commerce. It's because the United States Supreme Court says this violates a constitutional protection. A constitutional protection against cruel and unusual punishment. And because of that, it is cruel and unusual to execute a minor. So when we talk about limitations on states, one of them is the Dormant Commerce Clause, but the other one is does the state law violate a civil liberty or civil right that is enumerated in the United States Constitution? And here it does. State cannot do it. What about the 3 strikes law? Well, again, the argument was made that the 3 strikes law was cruel and unusual punishment. But in this case, the court said it wasn't. So yes, the state can do that. And that's how we understand federalism. So hopefully, after all this, you have a more comprehensive understanding of what the national government can do, what the state government can do, and the interaction between the two.